Good morning, Committee Chair, Senator Fincham, and your esteemed colleagues. I have a document. Zach, have you distributed this to all the members?
Yeah.
All right. This is a 14-minute page. I represent not only myself, my family, but hundreds of other families. What I'm going to tell you is how the court system has been subverted and abused by psychologists. And I hope you grant me the 14 or 15 minutes.
I'll give you 12.
Allow me to
Talk fast.
Yes, sir. Allow me to get through it and then ask questions, please. We're here to expose the despicable acts and deeply rooted corruption in family court system perpetrated by some reprobates over the last 20 years. Scoundrels that have leveraged flaws and created loopholes in our family court system for personal gain at the expense of our children. There are some great family court appointees. They solve family issues quickly with little expense. I personally have had experience with a few of these. Let us now turn our attention to how groups of organized family court appointees and their associates have taken advantage of children and families in crisis by creating additional problems with long-term adverse effects on the mental, emotional, and financial health of the family unit. They do this by taking advantage of the family court system. They do this for long-term profits, power, and personal capital gain, just like any other organized criminal activity. In many cases, the court appointees easily create a biased paradigm that creates, feeds, or lengthens an already horrible family situation. They do this at the expense of suffering, abused children, and parents. And this is how they do it. In high conflict custody court cases, family court typically appoints a therapeutic interventionist, a TI. This instantly creates a revenue stream for the appointee, a TI, therapist, psychologist, or court-appointed advisor. The length of time that revenue stream continues is highly dependent on the ability of the appointee to solve the problem. Do they solve the family problems quickly, or do they stretch out the problem? I've experienced both and have the hard evidence to back up these claims. This problem begs the question, is it the family court's job to fix families or to simply adjudicate according to Arizona law or their feelings? We believe these matters should be adjudicated adhering to the laws of Arizona and what is in the best interest of the child. The family court also requires each parent to supply an affidavit of financial information, or AFI. This discloses each parent's finances. The TI has access to the AFI. This is how they can size up the earning potential from each family. When the family court orders therapy, a TI is assigned. Typically, mother, father, and children are required to see a specific therapist assigned by the TI. This immediately sets the stage for multiple things to happen. A, required weekly therapy sessions ranging from $250 to $400 per hour on average for mother, father, child, or many children. At an average cost of $325 times the 3, that's $975 a week per family, or $50,000 a year if you take a few weeks vacation. It's purported that one TI has 97 cases in his case file. Multiply 50,000 times 97, near $5 million worth of income. It's a very lucrative profession, isn't it? B, supervised visitation. The costs vary. An example, $2,000 per month for 2 4-hour visits per month, or $24,000 per year. This is ordered in many cases. C, intensive family therapy, IFT. Estimated costs, mine was $15,000. I've heard up to $40,000 for these camps or intensive family therapy sessions. In addition, New terms were developed during the course of my case. There were pre-intensive family therapy costs, post-intensive family therapy costs, and the names for more charges developed as the case went on. I've listed my case if you like to review it, the numbers there on the sheet. D, a false narrative, and this is a very important part. A false narrative is created by the TI favoring the abusive parent. This sets up continuous actions by the good parent to save the children from further abuse. These actions are like hearings, cases, more psychological reviews, whatever they can do to save the child from further abuse. This false narrative capitalizes on the instinct of human nature to protect their young, mothers and fathers alike. There's good and bad in both sides of the camps, right, of the genders. The good parent will spend or do whatever they can legally to protect the children from further damage by the abusive parent, whatever they can. They'll spend every dime. The false narrative paints the good parent as bad and the abusive parent as good. This is typically reflected in false reports to the court by the TI. I'm going to repeat that. This is typically reflected in false reports to the court by the TI, and I have hard evidence of that.
I was just going to ask, Robert.
Well as others.
Is this your personal experience, or is this a generalized experience that is second or third hand?
Both.
Okay. Let's try
Personal experience and experience from talking to more than 20 parents who have had the same paradigm applied to them.
I appreciate that. So let's try and stick primarily to your first person experience, okay?
It's my intention over the summer to dig out more cases to give you more hard evidence.
All right, thank you.
You're welcome. This results in the abusive parent getting reoccurring temporary custody through any legal means available. One is a reoccurring no contact order. In my case and many others, a no contact order was or are issued without cause or due process, which violates parents' civil rights. You have to have due process to take a kid away from someone, temporary or not. This perpetuates family conflict instead of resolving it. Here's an example, and I've listed a case for you here, of Sachs versus Raymond Branton. It explains exactly what I've described with bias and false reports. You asked, do I have another case? There is one. In addition, I have multiple instances where the handwritten notes obtained through subpoena of multiple TIs that are in direct conflict with the reports provided to the family court system. Hard evidence. The judge created orders using false reports, thus causing additional damage to the family, while the TI and his circle of influence, colleagues, and army of therapists continue to profit from the weekly therapy fees collected. Remember, this therapy can go on for years and has gone on for years. Number 4, a circle of influence has been created and used by TIs. There's a specific group I and many other parents are now aware of. These circles of influence are used repeatedly in many cases. The false narrative is reinforced through multiple mental health care providers that remain loyal to the false narrative proffered by the leading TI. Businesses referred and repeated case by case to therapists who align to the false narrative, thus creating a group that has conspired to mislead the family court system. I've experienced this firsthand. Others have described the same web of therapists that they were or are ordered to see. Another means that they use is psychological evaluations. They're misused as punitive measures, ordered without cause. There's a high profit in this. They're demanded by the request of opposing counsel, sometimes by the leading TI. In my case, The ineptitude of these highly paid appointed professionals is clear and repeated in many other family court cases. In my case, the court orders state, father is to get a psychological evaluation, or words to that effect. And you can pull up the case and see the order. No specific provider or timeline was ordered. Father did as the court ordered, using a highly qualified, respected professional in the field of forensic psychology, family psychology. Cost $9,000. The TI declined to accept it at the next hearing, declined it, and ordered a second psychological evaluation by a specific individual within his circle of influence at an additional cost of $14,000. By the way, no personality disorders were discovered. But
Excuse me. Okay, so two things. No personality disorder was discovered in the first examination, correct?
correct,
Nor in the second.
correct.
Okay. This is just a general comment, not just for you, but for everybody testifying. We really need to, and so far you've done a pretty decent job. We got to focus on facts and your experience and not make allegations of crimes because, and here's why I say that. The facts will reveal any potential for perhaps a referral. I don't want to jump to the conclusion that a referral is necessary until we have the facts as a foundation, okay?
Okay.
All right, thank you. Please proceed.
I'll try to apply that as I understood.
You might have to kind of massage your remarks a little bit, but we don't want to make any criminal allegations at this point because this is a fact-finding hearing, not a presumption hearing, okay?
Right.
All right, thank you.
So, no personality disorders were discovered, but additional 90-day no contact orders were enforced while the process dragged on for months. The second psychologist doing the evaluation decided to take 6 weeks and go to Africa. I was not allowed to see my son during that time. I had to wait for the second psychological evaluation.
Okay, excuse me just a second. Let's go back to the first psychological exam.
Yes.
Were you able to submit that to insurance and have
No.
insurance cover it?
No, sir.
Was any of this covered by insurance?
These two psychological exams were not covered by insurance. And I
To
did
that-
have good Blue Cross insurance, very good insurance.
To that point, Chair,
Yes, ma'am.
thank you. To that point, I just wanted to state that court-ordered therapies are not covered by insurance. And usually it's the insurance is the one that makes that designation.
That's
I appreciate
correct.
that, Senator. It may be a distinction without a difference, but it doesn't sound like this was ordered by the court. This was ordered by a TI, who is not an officer of the court, but a contractor with the court.
That's correct. The court order, the judge asked for recommendations from the TI, as they often did, always did in my case. The suggestion or recommendation by the TI was to the judge, he should have a psychological evaluation. The court then ordered the psychological evaluation.
Okay, so there was indeed an underlying court order. Okay,
Yes.
all right. Thank you for the clarity. Go ahead.
Okay. This kept my son and I apart for an additional 90 days, an additional 90 days. This went on and on for 11 months.
And,
More,
excuse me, and that's because of the psychological examination
that was part of
that
it.
has been ordered.
Well, that was part of it.
Okay,
Initial order was done without cause,
okay,
okay? There was
Got
no
it.
just cause. There was no evidentiary hearing. It was just recommended by the psychologist, and the judge ordered it.
no foundation as
None.
to why this should be done.
None whatsoever. My rights were violated.
Okay, all right.
Point 6, the family court judge always asked the TI for their recommendations during my experience in my trial. This has been repeated by other parents to me. This is how they operate. The orders following the hearing or trial always or often follow the TI recommendations. apparently without gathering, reviewing, or giving appropriate weight to the hard evidence that is contrary to the TI reports or recommendations. Reference my case. It seems like the family court rulings and orders are being directed by the TI, not the judges. While this allows for plausible deniability on the judge's part, it also hands the power of the child-parent rights to a non-legal, unqualified party who can financially benefit greatly from the abuse of power and prolonged family crisis. Where are the checks and balances? Point 7, TIs are granted immunity. Immunity appears to be the broad and far-reaching. Too much power is handed to TIs in the family court system. That power may have been abused. I reference a case you can review, the Sachs versus Branton case. It goes right to that point. On 3 points in civil court, criminal court, and family court, Sachs lost. Immunity was cited, case dismissed.
Okay.
Those are facts. Family court does not always follow Arizona law. Point 8. Constitutional rights stripped away without due process, cite my case, removing children from a parent's care. More specific examples and legal citations are forthcoming from my attorney on my case, in particular, in the legal language, which I'm not qualified to provide.
Mr. Chair, Robert, I want to first make a comment on something you said. If these TIs are acting as judge, my biggest problem from a government these judges are elected by the people. The TIs are not elected. That is a huge problem. So I just want to say that because it's very disturbing to me. But I want to talk to you specifically because I had asked a little bit about the reunification type program. I guess, what was your experience with that? What did it cost you? How long were you kind of stuck in that hamster? Just all of the basics of that reunification
Certainly.
therapy.
The IFT program cost $15,000. The pre and post averaged, I think it ran up to about $4,500 from my recollection, okay? My experience with that program was 20 minutes with Dr. Branton, the TI, who ran the IFT, in his office. I got the bum's rush out of the office when he asked me to tell my son to do everything he said, regardless of what it was. My response to him was, I will tell my son to work with you in your program and do everything you say up until the point he does not feel safe. And we're talking about a very intelligent 15-year-old at this point in time, not a 5-year-old. He's old enough to know what's right and what's wrong. My experience beyond that was I was never invited to an intensive family therapy session again. Not one. I spent near $19,000 for intensive family therapy and got 20 minutes with Dr. Branton. Did that answer your question?
Okay. Please, we need to have you wrap up because I got a whole bunch of people in the holding pattern.
Understood. The damage doesn't end when the children reach the age of majority. A number of things to set the stage for long-term grifting of family resources, creating a continuous long-term revenue stream of therapy, and causes even longer-term problems when children age out. Children having reached the age of majority find themselves needing help to deal with the additional trauma caused by not only the abusive parent, but also the brainwashing done by the TIs who use dark psychology in their processes to reprogram the child to tell them their abusive parent isn't abusing them. It's all in their head. Then there is the emotional damage done to the good parents which can spawn the need for therapy to recover from the trauma of watching helplessly while their children are taken away, forced into the homes of the abuser to suffer additional abuse and brainwashing. Eventually, the good parents discover the brainwashing that the TIs have done to their children, making the child believe he is at fault. This is the goal I hear repeatedly. It is true in my case. They made my son feel like he was the problem, not the abusive parent. Testimony by survivors who aged out is available. See the video testimony, and I've cited Tori Nielsen, who spoke to the House of Representatives last year on 3/19/24. It's a very moving testimony. Please watch it. It'll give you greater insight into our problem that we're trying to overcome here. And that's all I have. I've got some sightings on the back page for my case, but
Okay, Robert, if you would, please make sure that Zach gets whatever materials you've got to turn over to us, and it'll be a part of the majority report. Members, any questions for Robert?
Yes, I have a question.
Representative Fink.
I was actually part of the, or helped out the parents to be able to get the ban on the reunification camps. But I see this intensive family therapy. Did that happen right at the time that we were getting that bill passed? And is that basically the substitute for these reunification camps?
it went hand in hand with reunification camps. Yes, it was going on at the time we were working on SB 1372. So that was coincidental to my case. So my son, luckily, didn't get drug off to another state or trafficked to another state for a reunification camp. Victoria Nielsen did, and you can see her testimony if you didn't hear it before. Did that answer your
was there.
question?
Well, yeah, I was there. So, but what I'm saying is that we banned reunification camps here. Is this intensive family therapy the loophole to be able to basically do the same thing?
I don't know. I only had 20 minutes of it.
Okay.
I just couldn't say. Other parents may be able to say,
Okay,
speak to
thank you.
that.
Well, that's also something that we can research and try and
Right.
validate. Okay. Members, any further questions? Robert, thank you very much for your testimony.
Thank you all.
All right.